Okay, Mr. Chair, it's recording.
Okay, so I'll entertain a motion to open the meeting.
So moved.
Second, all in favor?
Aye.
Aye.
The meeting is open for any of our community members watching. You can watch on LMC TV on the live stream on YouTube, or as a participant on Zoom, which if you follow these meetings, you've probably figured out by now. The information to do so is at the top of the posted agenda. And this is what we do now instead of telling people where the exits are. Our original agenda had two applicants before us this evening. The applicants on both of those projects have asked that we adjourn it in part because of issues raised on our work session on Monday night. However, on 1165 Grecian Point, I think there's one thing we can work through, which is an update on contact with the DEC. I think, William, you can fill us in on reaching out to them.
Yes, basically, what we said to DEC, we sent them an email just explaining to them that the board will not review consistency until its November 18th meeting. That's where we left things.
All right, that's all we can tell DEC for right now. And there are some outstanding items that hopefully will all be lined up and the applicant completely teed up for us for our November meeting. 52 Shore Acres was also on the agenda, and they have asked to move that back as well. So I expect we will see them also at our November 18 meeting, which brings us to.
Chair, can I ask
Yeah, go ahead. Doreen?
regarding the previous application? I know you just mentioned the next one. Are we going to receive the updated plans since they're submitting them to the DEC? Or are we basing our consistency determination on what we have in front of us?
Well, I think you were looking for a topo, and I think that's been added.
No, I believe Kristen Motel mentioned in the correspondence that's on the agenda that they've submitted updated plans to the DEC. So are we going to be in receipt of those so that we can review those prior to our next meeting? Because we should, even though they provided them to the DEC, we should also be copied on those. Otherwise, we're looking at the current plans, which may not be updated.
Oh, I understand that Kristen Motel, who's counsel for this applicant, has been monitoring this meeting and is able to address that. So we might as well give her a chance to do that. William, can you promote her so she
Yeah,
can?
I just promoted her.
Great, thank you. Good evening, Ms. Motel.
Good evening, commissioners. Good to see you all. Yes, per my correspondence, I believe your commission received yesterday, we did file amended plans and a response to DEC's comments on October 13th. The commissioners will be receiving copies of that as well as all of our amended materials by the, I believe it's the November 4th deadline for your November meeting. So you'll have copies of all of those materials. We're also in touch with the DEC today, so they've received everything. They let us know they were reviewing it today.
Thank you.
You're welcome.
Yeah, thank you.
All right, very helpful. Have a good evening.
Good evening.
And I believe that brings us to our administrative portion of the agenda. We have several items up. The tree ordinance.
Excuse me, Thomas. Can I interrupt for a second before you? This is Sven.
Yes, Sven.
Was I only on for the applicant review, or did you want me for something else?
Oh, I was kind of wondering why you were on actually. So
Okay.
I probably, I did not anticipate asking for your assistance with the tree law or the wetlands law. So I think you were probably here for the applicants, and probably somebody ought to have let you know that they were punted.
Okay.
I think you can go.
Great,
Thank you.
thank you. Good night.
Okay, the tree ordinance we had a chance to look at. That is before us for a recommendation of the Board of Trustees concerning adoption or amendment. We've had a chance to go through this, and I know that Seamus has a comment, and then I'll open it up to other folks.
Yes, thanks, Thomas. So my comment, I just actually gave some thought to really the point, Doreen, that you raised on our work session on section 318.7E, which is construction damage. So I was thinking two things. So I thought that the construction damage provision should make it more clear that that this is not an option to sort of damage a tree and then replace it. That construction plans must include accommodations to avoid any unintended damage to trees, and then say that any tree accidentally damaged or removed without permission during construction or development of the property must be replaced in kind. And I thought it should be clear that penalties would be paid as well. I thought it was my read of the document that that would get picked up in the penalties. I don't know if that's a correct read or not. That's pretty much the substance of my comment, and that is my only comment on the tree law.
I got a red line in an email from you, which I don't remember if you shared it with the staff also, but it looked okay.
I did not. I can forward it to William if that's helpful, but yeah.
Yes,
Yeah,
please,
can you forward
definitely.
that to William? Because okay, Martin.
Yeah, I would like to add on to what Seamus was saying as well. And it hit me as funny that you wouldn't ask them to replace it with another mature tree, because I mean, that would de-incentivize them to damage a tree and put in 3 small trees. That incentivizes them to damage a tree. But if they would have to pay to replace it with a mature tree, which you can do, you can buy a tree of any size and have it put in. I think that language should be in there as instead of the replace it with small trees of the whatever.
Okay, I think David had some comments as well.
Yeah, and I'm sorry, I apologize. I started to work 2 days a week at the office, and I found one thing I never planned on, and that is that I leave things in the wrong place. So this shouldn't be an exception. My notes are there, but I do have some problems with this, both substantively and procedurally. Substantively, as I understand it, the most amount of trees you can take down in a 3-year period is 3 trees if they're over the 8 inches. That's how I read that. So therefore, if we have vacant lots or lots that are developable, and they have trees where you'd have to take them down in order to build, and there were many other trees, I guess what you're saying is that we've just made those non-buildable lots, I would suppose, which means the village just bought those at fair market value. Because that's effectively if I bought a lot, if I had a half-acre lot, let's say, or a quarter of an acre lot that I wanted to build on, and it had not been built on, it might be 24 trees might be on it. And I'd have to remove, let's say, 6 or 7 of them, not myself, but whoever was doing this. And so they're basically precluded from doing that. If I was the owner, what I would do is I would get the property appraised as if it was buildable. I would give the bill to the village and say, thank you, you just own my lot. Because basically it's a taking at that point if I can't build on it. So I don't quite grasp the understanding. I think that I'm very much in favor of ordinances that limit ability to take down large trees and protect them. But this, I think, deals with something different. I think there's blindness on the substance of that. And then you've got where if it's a significant tree or a significant shrub, is protected. I don't know what that means. And I think I've
Where
learned
where
this
are
much
you,
about
where are
void
you,
for
where are
vagueness.
you reading, it- where are you reading it from, David?
Protected tree or shrub.
Yeah.
F, a significant tree or shrub. I don't understand that. I really don't. I don't know what that means. My other because I think that doesn't help. You're supposed to read a code. This is a code with, this is a substantially, results in substantial imposition of penalties upon residents. And, you know, I might have a lovely shrub out there that I said, well, it's no good. My driveway gets in the way or what have you. I'm removing it. I didn't know it was significant. You know, it's could be, I don't know how big the shrub is. It's certainly not, could be very small. I don't know what a significant tree is. I don't know what a significant shrub is.
There is a definition in the code of significant tree and shrub.
Oh, is there? Okay, where's that? I'm sorry.
I'm not sure how it would be indicated on said tree, however, if there's like a database, but in the code, it does describe,
It's up in the definitions.
yes, in the definitions.
Of this section? Okay, that's fine.
Yeah, if you scroll up to the top where all definitions are, there's a definition that says significant tree or shrub.
A significant tree. Oh, I'm sorry. Oh, a tree, shrub or public desert on public property. Oh, well, it's defining them only on public property. Oh, okay. So therefore it wouldn't apply to anything on private property, correct?
Correct.
Oh, all right, that's,
There you go.
well, I guess that's okay. I also think that I'm not sure about replacement. I think that's really it depends why. What if someone is putting an extension on their house or adding a garage or something that they have every right to do in the village? And they need to take down an 8-inch tree, which is about yay big. They can't do it without getting a permit and replacing it. I don't know. I have a question about that. I certainly am not comfortable with that.
I didn't read it that way, David. I read it as that you had to get permission, and if you had permission, then you could do it. But if you didn't have permission, that's what this is trying to prevent, is for if you don't have permission to move that 8-inch tree.
Oh, you're saying if I do it, I thought that the building inspector must require, maybe it's me, on page 9, subsection G, conditions in granting a permit to remove it, which is what we just spoke of. And it says the building inspector must require, as a condition of the tree removal permit, that the applicant replace each tree that is removed, et cetera, et cetera, et cetera. And then it goes through the size. So I think that maybe there's another section that may be negating that, and that's sort of be modified, but I don't think that I have a little problem with the replacement concept. As well as as I said earlier, if there are trees, the Grecian Point Roadhouse that we talked about earlier is an example of a house. Now, I think they may have overdone it, but that property had not been maintained in the sense that whoever lived there for 20 years or 30 years, it was full of trees. It was beautiful, but it was a wooded lot. There was no yard anywhere. And I guess if they wanted to take them down, they would have been limited to 3 and they would have had to replace them. So it sort of raises the issue about, well, that's great. Well, I guess I just don't have the yard. So that's from a substantive. I think that procedurally, I have tremendous difficulty with an ordinance, which basically allows a village to enter property without a warrant, without permission, without consent. And I think the law, and I have not researched this recently, but the law came out of a Supreme Court case a number of years ago, probably many years ago, but it's been followed to my knowledge. You cannot, when if you try to come on, you ask to come on, and but for extingent circumstances of a real danger or something, I think I think you can't do that. I don't think you can enter. I also have a lot of trouble with fines of this type being imposed unilaterally by whoever imposes them, and then if you don't like them, you appeal them to a village manager. I think that requires more. And certainly, if I were to have 2-foot violation of a driveway I built or an improvement that I made, I would end up being summoned to go to the court, and I would have my procedures and my defense. I also think that there's references in here to things being done without notice. And I'll be candid with you. I feel like these things should be done correctly, but it's like if I'm a village, why am I opening myself up? Because I can assure you that you're going to get sued for that. Because if I was away in this, I'm entitled to notice, whether it's by certified mail, whether it's by smacking it on my door, I don't know. But I don't understand. There's a driving, almost a we're right, you're wrong concept in the procedure here. And I have trouble with that. I have trouble with fines of that type when they're just imposed administratively and there's no, I mean, if you get a parking ticket, last night I went to Sal's, walked in, picked my bike, came out, and I met the parking officer who was very gracious, having just handed me the ticket. You don't have to put it on my windshield. Here I am. You know, believe it or not, on that, I have a right to go in and have a hearing if I want to. Or I'll pay the $25, which obviously is what I would be inclined to do. So I have problems with those types of procedures here. And then you have another little issue. And you talked about replacement, Martin, and it's a good point, because I think I understand that in most cases. I happen to be in a house that was built in 1929 by the person who was developing this area. And they built trees here. They put trees on the road. Those trees cost me about $2,000 every 4 or 5 years to have climbers go up and trim. Now, I wouldn't want to be my neighbor because I find when the wind blows, boy, I mean, they're huge trees. And my point is, I don't know how I'd go about ever replacing them. And
Well, the replacement was for construction damage. That's the clause that we were looking at, was construction damage. That's what I was talking about specifically.
okay.
And that's where Doreen's point came up during the working session, is that you don't want to incentivize to somebody to just back up the backhoe and hit the tree while they're doing the construction so that they can just remove the tree.
I agree with you. Absolutely. But that's got nothing to do with someone having a bona fide reason. Those trees may or may not be diseased or damaged. I don't know.
Right. No, I'm not contesting bona fide reasons. I'm talking about construction damage.
Yeah, okay. I mean, but I think that it applies. Technically, I would not be able to take those down. I have an apple tree that's from 1920s. It's for 10 years, it keeps on leaning. And every time there's a storm, another portion of it goes down. It's on its last threads. My point is, I guess I have to, the last thing I would ever want to do is replace it because it's smack in the middle of my yard. And I left it there only because it's been there since 1929, and I respect that. I'm not going to be the one to take it down. Now it's about its own. It's decided to either commit suicide or do something, but it's not much left of it. So I don't know. I have a problem with the procedure and the substance on that. And there's just something, I think that there needs to be some clauses that recognize that if you're buying a lot to make an improvement on, you're adding on something, if you're going to do some construction. And I agree with you, Martin. It should be, you don't want to incentivize anybody. Listen, I have a copper beech here that I won't even let people walk under. I especially don't let someone go there. They're shallow rooted and it's a huge, amazing tree. What I'm seeing here is you can't. When you're not, we won't give you notice, and here's what we can do. And if you don't like it, we're going to fine you all of this. To me,
David,
that's a breeding ground for issues.
David, have you looked, and I won't confess to having a legal read of this, not being an attorney, but have you looked at 318.8B, which is, reasons why you can remove trees, which covers permitted uses of the property, approved site plans and landscape plans. It seems to me generally, and
Where now? You're in 318.
Yeah, I think that covers, Seamus, I think that covers what David's talking about, is having a lot that if you have an approved landscape plan, you can take those trees out.
yeah.
Even though it's limited to 3?
Well, I don't know if it is at that point, but
I don't read it that way. This is subject to that
318.8B, yeah.
Which one is it? A and B?
318.8B.
318-8B.
Correct.
I have, yeah. The protected tree is within 10 feet. They find it interferes with the permitted use of the property. And is specifically identified or removal on an approved wetland permit, special use permit, subdivision, or landscape plan.
It's because it seems to me, and I'm not sure if anything, either contradicts this or limits it, but it seems to me like to do anything, of substance, you need to go get a landscape plan or a site plan or, some sort of permit. And this just adds trees into that you need to go and get such a permit. But I think it would cover a lot of the things that you listed, David, between 2, which is if a tree is, dead, dying, diseased, and is going to fall down, I think that it gets covered. And then 3, I think to me reads as you can have a normal, looking property with a house and yard, perhaps, because that I think.
I still think you're limited to the 3.
Oh, you know what? I'm reading it again, David, and I think you're right. B is the criteria for removal of a protected tree. C says may not grant a permit to remove a protected tree on private property if the property owner seeks a permit to remove more than 3.
I think it comes from the right place. I'll shut up now, but I think it comes from the right place. Because I've been involved with litigation on the light permit, the lighting, dark skies laws. And I think this comes from the right place, and you don't want to incentivize it. You don't want trees removed, especially valuable trees and good trees. But I don't see a balance. I don't see someone saying, okay, well, if this tree falls, do I have to replace a tree? For 30 years I've lived here, and for 30 years I've let a tree go right in the middle, where when my kids were growing up, we had to play ball around it in the middle of the yard. Why? Because I said, we're not taking it down. That's why. It has now come 80% down. And I don't believe, if you look at subsection G on the condition of the replacement tree, I would think they don't deal about location. But if it's calling it replacement, I guess technically it would seem logical. I have to replace it there. I can't replace it on your property, Martin, or somewhere else on mine. I just don't understand. I just think there's, that's my biggest thing. And the other thing is, I'm sorry, but I will tell you this, that if I got a notice, if I came home one day and they said, oh, we've removed this, or we've done this, and here's your fine, and if you don't like it, you can write the village manager a letter, I know where I would go. I'll file in federal court the next day. I don't know why. Why would I? And I would tell the judge, this is a wonderful thing, but it's abuse in the process. I have never seen, I want to just end up with one thing. I have never seen something like this written where you go out of your way to say, and there will be no notice is required. You get notice for everything. It's how you have to get it. I agree. It doesn't have to be served on you. But why? Where are we coming from is my concern. It's not a very friendly approach.
So if section C limits B, what's the procedural, does that mean that someone would be going for some sort of variance if they wanted to take a number of trees down? Does anyone know?
Is this within the zoning code 318?
No.
It's not within the
Well-
zoning code.
No, that's not a
It's
code
a-
provision.
Section under streets and sidewalks in the code, also about trees. Did
Yeah, but
anybody
Not
ever?
that.
But no, it's not in the zone. I don't think it's in the zoning code. But did the writer of this law look to see what's in the code to make sure at least what's currently in the code isn't in conflict with what's here?
During the laws, I think we're on our 8th year, so it's had several authors.
get-
I
understand, Christy, but what I'm saying is if this is going into the code, I think before it's adopted, somebody should really check what is in the code currently, because there are different sections in the code regarding trees. And I'm hoping there's not a repeat or a conflict with what might appear to be in the code.
I'm sure it's
last-
been checked. But
Last time I brought up the same
Speaking,
fact
right,
that Dave brought up, about someone, not giving you notice and doing something on your property or removing a tree or whatever. And that's an overreach, which I agree. I was, thinking about that. The other thing, too, is what about the type of tree it is? Based on our commission and what we do, there are a lot of native trees that might be cut down on a site development plan, landscape plan. And let's say you had 5 oaks and 6 hickories that needed to be removed. This law doesn't pertain to that specific species.
That's correct.
And if it's in a wetlands, it seems to me that we should get into some native type things. And
Well,
what's on the
hang
site.
on, Doreen. Hang on, Doreen. It doesn't specify the species, but it does specify native trees, non-invasive. Replacement has to
No,
be
I get that.
non-invasive.
Here's my point. The city of Rye had a publication. It's a video. They're doing a wonderful job with trees and in their community. And it talks about what's native here, what's native in wetlands, what's native on, within Westchester County. A Copper Beech in Dave's neighborhood might be great for the flora and fauna that love to hang with it. So here's my point. If a site development plan requires removing a specific species of tree, we need to, if a removal needs to be done of a tree, the replacement should be not only in kind, but what the species specific of what it is, because that's how you'll maintain habitat. I don't see anything in this code that says that.
So you would specify same in G1A, you would specify same species?
Sure, on the replacement.
What would preclude an owner from deciding that he prefers because he likes another type of tree, a different dogwood or something? What is the public interest, assuming it's not a type of tree that would be problematic and invasive or destructive? Why are we telling someone why they like the color blue and you like the color green? I don't follow.
Dave,
it.
I think from the perspective of our LWRP and habitat, okay, especially in wetlands.
Well, wetlands are a different thing anyway, but okay, I'm with you. I understand your point.
I prefaced it by saying that. I don't know if it's coming through on audio that way.
Yeah,
for
we
what
hear
we
you.
deal with, especially in wetlands.
Okay, our job here is to recommend to the Board of Trustees adoption or amendment. So in order to keep this from just being an endless discussion, we've got to sort of systematize this and decide what we're going to tell the board, because we have to make a recommendation. I want to get, it is probably asking too much to draft everything tonight. So instead of just sort of, making motions on specific line edits, which is tough to do in this format, what I want to do is get a sense of the commissioners on certain specific matters, and then try to draft and then send out for comment. That way we can get a set of comments together that reflect what the board thinks. The first thing I want to take up is Seamus's comment that we should deal with the accident by using language to clarify that it's, you don't have that the damage provision for construction requires a plan in each construction instance to avoid damage to mature trees, and that what was the other part of that, Seamus? You have to have a plan to avoid accidental damage to protected trees and
Yeah, and then I thought maybe to clarify that it also comes with a penalty, and I liked Martin's suggestion potentially of if it's a mature tree, replace it with a mature tree. I think that one has the right to be fairly punitive since it should, a lot of care should be taken.
Right. That's where I was coming from too, is that one should be, the other ones I sort of see where David's coming from.
So if there's a, or Seamus, if there's a large tree that's, basically what you're saying is once that tree exists on the property, if it's not dying, dead, can one remove it?
He's not saying that.
I don't think that's
I
relevant.
didn't say is, I'm trying to understand.
No. No, David, this is very, very narrow point, I think.
Yeah, please.
There's a provision that allows for the replacement of a tree that is damaged in construction.
Okay.
That I think we're just trying to say, if you are working in construction, and I'm not going to put it artfully right now, be careful. And if you mess it up, it will be punitive because you'll have to replace it in kind. So that's not
specific. Yeah, specifically in the circumstance where it is a replacement due to construction damage. Construction damage replacement would have to be mature tree so that it is truly in kind and therefore expensive, so as to incentivize people to follow very carefully the plan to avoid damaging protected trees in construction.
Yeah.
Taking that as a package, that there has to be a plan to avoid construction damage to protected trees and mature tree replacement. I want to get a sense of the commission. Who's in favor of that as a recommended amendment?
If it's construction, I'm sorry, I couldn't hear you.
Specifically for construction, the requirements that there be a plan to avoid damage to protected trees, and that construction damaged trees specifically have to be replaced by mature trees.
Unless they had permission to remove them.
Right. No, if it's an accidental construction damaged tree specifically.
That's fine. I think, yes.
Okay.
Would you like language if a mature tree, or if a tree is damaged, if a tree that is on the tree protection plan, because when we look at SWIPs, they have tree protection, right? If a tree on a development plan that is protected,
It doesn't have to be that specific, Doreen. It's if you hit any tree that you're not supposed to hit, that's it.
Right.
It doesn't need to be.
I can draft the language. I'm looking for a sense of whether the commission is on board with recommending that as an amendment when this reaches the Board of Trustees.
Thomas,
Definitely.
I like that. I like that as well. I think you just have to be specific with it. It's not only backing into trees, it's compacting soil around root systems.
Yep.
There's other considerations, but there should be like some kind of intent. If something is damaged accidentally or something, it's unavoidable. It's got to have a little flexibility. This has got to be tailored towards somebody who, what's the girdling a tree, cutting it to a perfectly healthy tree to sabotage it because it's blocking a view, and he wants and there's a certain mens rea about it, right? I mean, we don't want to stifle development entirely, so we have to just create some guidelines and also have some kind of intent clause in there where it's an intentional or willful destruction of a perfectly healthy tree.
Andrew, there's already some language in there, I think, that addresses part of your issue, which is if a tree is just a little bit damaged, I think that if I'm trying to pull it up, I think that what they say is, get an arborist in and, help it. I think that what I was trying to address is really a total loss of a tree type event. And personally, I'm not inclined to allow, accidents happen. You just have to come and bring a mature tree in my opinion.
I mean, that's kind of the point of the specific plan for construction to avoid damage to a mature tree, right? If you've got a protected tree there, you're giving people plenty of warning. You have to specifically plan to not damage that tree. And if you do, you're going to have to replace it with a mature tree, and that's expensive. So be careful.
Right. Exactly.
Is your understanding, Thomas, that this applies to the people who do it or owners or both?
Isn't that going to be between them and their construction contract? I mean, I don't know.
I don't know.
I believe it's only the owners.
Yeah, this is the property owner, whether the contractor bears responsibility, that's between them and the property owner.
Yeah, I think a property owner could subsequently probably sue the contracting company.
And if it's, but it
And
would.
also may have insurance
You
coverage.
mentioned some kind of intent. It would have to be with the, if somebody came on the property without authorization and removed trees. Yes, I had that
Well,
done.
but wait a minute.
No,
This is not
about
that.
damage.
This is specific
David,
to
you keep going
construction.
on to different things. This is specifically about
I'm with it.
construction damage.
Construction damage, fine. Yeah.
Okay. Okay. Now David's issues. I want to get a sense of that the issue of in 9C, the 3-tree limit to the permitting authority, which in some cases, now I don't know that there are any lots that you couldn't build on right now in Merrimack if you couldn't cut 3 trees, because we're pretty developed, but at least in theory that could constitute a taking. Do we want to, I want to get a sense of the commissioners whether we want to ask the Board of Trustees to amend that to provide wiggle room such that it not create a taking or prevent a buildable lot from being buildable because of the inability to grant a permit to remove 3 or more trees.
My opinion on that is I am trying to think of how that fits in our purview, although I agree with the comment, how it fits in our purview. I am not sure it does unless the take is that we just, like the tree law and what it does, and so we want it to be a good law. But I don't think I see anything in the LWRP that makes me want to pursue that too far. But I'm open to other commissioners' comments, because that's what I'm struggling with, is whether to put emphasis on just let's make this a very good law versus.
Well, could that just be simply a recommendation and not within our?
No. It's our wetlands. It's in our wetlands policy. Trees is specifically mentioned.
But Dorian, I think this recommendation would be to make it easier for people to cut down trees.
He's talking specifically about the thing I just said, which is I want to get a sense of the commissioners about David's comment that we should provide for some elasticity to the 3-tree limit in sub C of the permitting authority, so that it not create a taking when somebody's unable to cut enough trees to make a buildable lot buildable. Okay.
Yes.
Seamus's point, if I can finish, Doreen. Seamus's point is that specifically that recommendation for that amendment may be outside of the scope of what we do.
What section of the code, of the proposed code, is this in?
318, I'm not here anymore, 318.8C?
G, I'm sorry, I flipped to the wrong part. 318.8C1.
While you're looking at that, could I just ask you a question in connection with that? What if I have 4 trees that are damaged, as happened in my house once in a storm? Am I limited if they're protected by definition because of their size?
Well, wait, I want to go back. Hang on a second, Dave. I want to go back to the problem that we think we have. The building inspector may grant a permit to remove protected tree on private property. Blah, blah, blah. D, no permit is required for the removal of a tree in accordance with a tree preservation plan approved by the planning board.
Mm-hmm.
That takes care of what we do.
Yeah, how the priority of A, B, C, D, et cetera is applied is beyond me, I think, as a non-attorney, on how they limit each other.
Well, it says building permit.
To removal of trees on private property. And you don't need a permit for the removal of trees or trees in accordance with the tree preservation plan approved by the planning board. Site development plan approval would probably be required
But that
for
doesn't-
developing a lot.
D probably takes care of your problem, David, as I'm looking at it again.
No, if I have 3 trees that are destroyed, I mean, they're not.
No, I mean your other problem, the takings problem. If you've got a buildable lot, planning board can let you out of it.
Yeah, I understand that, but I don't want to go to the, if I have 3 trees, you're saying that anyone in the village that has trees that are basically destroyed or split apart, as I've had happen once. I had a row in the back and we had a terrible storm probably 5-10 years ago. And I have there was probably 6 of them, there's 2 left. I let those 2 try to make it, but they're saying that if I have more than 3, I can't get a permit.
So you're asking for a provision for storm damage?
Or
No,
Martin, it almost seems like if you,
No,
I'm not following why.
No,
I
Gentlemen,
if the tree is damaged or if there's an issue with the tree,
Right.
in that sense, I don't believe you're prohibited from removing it just because it's a protected tree. In fact, you're encouraged to get rid of trees that
No.
would be
No,
dangerous.
but-
Wait,
Yeah.
Christy, where are you looking? Because
Hold on.
318.8B2, I see what David's saying. 318.8B2 gives the village manager the ability to authorize the removal of a damaged tree if it's
Yeah.
damaged or diseased. That's subject to the C limits that, right?
Ah.
And
I don't think it's meant to limit that, so I would include that as a comment. I don't think that C is meant to say that if you have 3 dangerous trees, but they're protected, you're not allowed to remove them.
and does
So
that,
if it's unclear, I would put that as a comment and ask for
Okay.
to review it and make
and
sure. that they're-
Christy, I would think that would solve almost everything we're talking about if it also means that B3, B4, B1 all aren't limited by C.
Well, the
Yeah.
permit,
and that's a good point too, because B1 to me is, let's see, the reason for that would be if your tree would then knock into your house or whatever it may be. So it's a potential damage. I would send comment. I think that it's not clear, but I don't believe that they're meant to limit, or that C is meant to limit those provisions.
okay, so that's our second comment. I think I have the sense of that. Our first comment is the one we discussed about construction damage and construction plan. Our second comment is going to be that the 3 tree limitation in C and the limitations in C more generally should be clarified as they pertain to B and D. And we can flesh that out a little bit in language, and everybody will have a chance to look at it. The notice, now, if I understand correctly, and I may have missed something, the no notice access to property is limited to dangerous trees, those that might endanger life or property, right?
I found it somewhere else. I can't remember.
That's
Let's
why
see.
That's why I read it, Thomas.
B1. In what
Yep.
section? I didn't write it down. Hang on, I'm going to find it again. I don't think it dealt with dangerous trees. Because David found it too. We both found it. And I was recommended to go, when they do the hearing because, that's a personal thing. But
And if
no,
You know what? It's 318-7.
7, yeah, that's it.
B.
That's A2. I'm sorry, B. B1.
That's again pointing to dangerous trees.
Wait,
we're
Hang
somewhere
on.
else too.
hold on, Christy. Hang on. No, 318-7.
Yes.
Every owner of private 7A, every owner of private property in which any tree, shrub, or other planting is located must, at the property owner's expense, prune the branches of any tree, shrub, or other plant on the owner's property, obstructing or overhanging any right of way within the village, so that the branches do not obstruct the clear space between the surface of the street or sidewalk and 8 feet above the surface. That's not something that is an imminent danger to life or even property. That's obstruction of a right of way, which is different.
Well,
Yeah.
I mean, I think we can view it differently, but I think you're right that it's meant to do that as well. But I don't know if that means then that they're pruning from the village side. So that's sort of the way that I read it, but let me look at it quickly. Prune.
No, it doesn't say that, because then the A obligations are then imported into B. A sets forth the obligation of the property owner, and then B says if the property owner fails to satisfy the property owner's responsibility under A, the village manager or the village manager's designee may cause the tree, shrub, or other planting to be pruned without notice to the property owner, which is at the property owner's expense, which from the right of way side, I understand,
That's what I think it might
and
pertain
direct
to.
the owner of the property to remove
So like
the
if I'm on a sidewalk and
prune
your
tree.
tree's hanging over, I'm gonna stand on the sidewalk and cut that half off. That's the way that I view
Well,
it.
That's the difference.
I understand that, but that's number one of A, but number two
It's
says
removal of a
remove
dangerous tree.
when directed by the village manager or the village manager's designee any dangerous tree located on the owner's property.
Well, but that's not access to your property without notice. That allows the village manager to tell you your tree's dangerous. You got to take that one down.
Well, it
It's in
doesn't-
another,
And how does that decision get made?
Doesn't the same logic hold though, Thomas? Because doesn't that section A2 get purported into B and then can be done? That tree could be removed without you notice.
Yeah, I think Seamus is.
Well, B is specific on that, right? B says if the owner fails to satisfy their responsibilities, the village manager may direct the owner, B2, direct the owner of the property to remove or prune the tree so that it complies. It doesn't say that if the tree is dangerous, that if you fail to do A2, that if we've told you the tree's dangerous and you haven't removed it, that we can go on your property and remove it. B1 says cause the tree, shrub, or planting to be pruned, right? Doesn't say remove it. B1 says, look, if it's over the right of way and we need to prune that tree and you're not doing your job, the village manager can cause the tree to be pruned without notice.
I
Okay.
agree with that.
Right.
I think that it's limited to pruning rather than removing. In the
Yeah,
end.
B1 doesn't say we can come on your property and cut the tree off. In fact, it doesn't say we can come on your property at all. It says if you're not pruning the tree and the tree's over the right of way, we can prune the tree and we don't have to tell you. Doesn't say access to the property. That's not the same thing.
Let's clarify that, because if you read as written, it does say.
look at D.
Village right to,
Yeah.
all right, now I'm looking at D. Village right to enter private property when a complaint is filed that a dangerous tree exists on private property.
Now
That isn't,
that doesn't
That's
have
not
the
kosher.
language that David really dislikes, which is
So
to
it's-
explicitly say no notice. It does not have that language, right?
Which is a.
But we're really talking about, see, as I've looked at it, I don't really have a problem with 318.7B. D, I think, D as in David, I think we probably have a sense of the commissioners that ought to require a notice provision.
But Thomas, if
Right.
you go back on A and B, that A2 still is there. There's a determination that there's a dangerous tree in both of them, right? And it says here when,
A2 is a determination by the village manager that a tree is dangerous.
and if you take a look at D, would you tell me what's meant by a complaint is filed? What is a complaint? I mean, I don't know. Is it a term of art or is it just a complaint?
No, that's not capitalized. I think that means that somebody emails the village manager and says the tree on David's property is dangerous.
Right. So someone says a tree inside my property is dangerous because it could bang into my back door and cause me injury. I appreciate their concern as my neighbor. But don't I get the opportunity to say something and be heard on that? I don't see anything like that here procedurally. It's like, I be the village manager, or I be this, and this is my determination. To which I say, yeah, me too.
Okay, so D, so what we're saying is D ought to require both notice and an opportunity to respond.
I think so, yeah. I think any determinations made absent extenuating circumstances, obviously. Thing
Okay,
looming. Listen,
all
I
right,
get hit.
what
My
ab-
electrical wires down this year and this. I mean, be real, but okay.
I got your concern. I'm trying to keep us moving. 318 318.7 D. I want to get a sense of the commissioners as to whether we think that we ought to recommend to the Board of Trustees that there be a notice requirement and opportunity to respond.
Oh, definitely. That's what's in the current code now.
I think that should be a general provision throughout, that anytime a determination is made, that a notice be given.
Yes.
And so that
And that
should,
should be an opportunity.
that should apply to the entire document.
And that you have an opportunity to say you're wrong and here's why.
Right.
Yeah.
That's what I said. That's what I just said.
Yeah.
That you
Well,
got notice and the
notice
opportunity to respond.
be heard. Doesn't have to be that.
More,
You have to have that notice and opportunity to be heard.
whoa, wait. More importantly, notice should be given to come on your property to evaluate a complaint.
Yeah.
You know,
I
give
got
you the
comment.
opportunity to say, let's, you know, can I come on your permission to enter the property?
Yeah.
Can
Yeah,
we?
that's what I was saying, Doreen, is that anytime a determination needs to be made, you should be given a notice and a opportunity to respond across this whole document. So
I got the comment. I see Seamus trying to say something.
Can, how do commissioners feel about characterizing our comments in two buckets? LWRP related and just things that we think, you know, as the people who have looked carefully at the law that we think might, you know, make it a better law. I just want to kind of maybe be clear on the priority on ones that we think are specific to what our commission is tasked with.
You got a good point there. I can draft so that it's readily apparent where we're talking about what's, you know, what may be necessary to make sure that the law survives scrutiny and what is necessary to be consistent with our LWRP. Okay.
With
And-
respect,
Yeah. So I think that covers the comments.
No, but I think with regard
one
to
more,
on the property, it's more than just notice. They got to get permission or a warrant. I believe that to be the status of the law in the state of New York, both under the New York Constitution and under the federal one. You cannot, building inspectors cannot go on a property if the party says you can't, absent an emergency, obviously. But it's a Fourth Amendment issue.
May I just give a friendly reminder that this law as is likely to change drastically. They've already put off the public hearing at this point. They've received a lot of public comments that are very adamantly scrutinizing the private property provision. So just, we appreciate all the comments, but just a reminder that this may change.
Everyone else has said the same thing. So that's probably, yeah, I got it.
well, here's a comment I'm going to make, and it's from personal experience, but not personal. Okay, LWRP related, and tree related. There's a particular person. There are arborists, and then there are arborists who really know how to evaluate trees that may potentially have damage or disease or so on and so forth. I'm not seeing anything within this law, especially for those in wetlands, because they are in growing conditions and they're specific trees. But it doesn't say, or I'm missing who the village is going to use to evaluate a complaint on a tree, a damage to tree, so on and so forth.
Jerry Barrio is, I believe he's a certified arborist, so it won't be himself, but he's very, very familiar with trees. So my assumption is he will be a good resource for picking a good arborist and will be knowledgeable on these issues.
And Doreen, I think there is a standard here that seemed to me to be generally applied throughout when it would be needed to be, which is that there needs to be a certified arborist that's certified by the International Society of Arboriculture.
Mm-hmm.
Right.
Now, there may be better or
Right.
worse, just like there's better or worse of, you know, anything.
Okay.
That I've seen them top off trees. which shouldn't be done on neighbor's
Right.
property.
Okay.
I'm just saying.
I think I've got enough to draft. Let's move on to the wetlands law. We've been around a few times, and Christie, unless I missed something, you circulated a revised version in time for this meeting.
With the
Leave it,
comments
yeah.
that were discussed on Monday night. I know that Doreen had some concerns about missing definitions, but the latest draft that I was provided didn't have those definitions. If she has a different draft, or if I don't have the latest draft, then this is obviously an issue that will have to be addressed. But the one that I was provided did not have either of those definitions.
Okay, this has been around a few times. We looked at it Monday night, and we've got revisions that reflect the discussion that we had on Monday. Unless somebody's got another specific proposed amendment to this, I'm going to vote this as a recommendation to forward to the Board of Trustees for adoption.
So are we including it with those two definitions I circulated that were in the actual draft that we approved when we finalized it back in April?
Now I got to go look at those definitions.
When I sent the email that those two, it's wetland hydrology and wetlands and watercourse buffers. Because if we don't add those, adjacent area in circulating this to the Board of Trustees says see watercourse buffer or whatever it was, wetlands buffer. Sent an email and Chris sent an email yesterday.
Do you have a copy of what version of the law you're using so that I can see it?
I'd have to go back through my emails. That could take some time. It was the last draft that went around in April
Okay, because
when that was it.
April's a long time ago. This went around for in time for Monday's meeting and in time for this meeting.
Right,
Christie,
what was posted to our agenda had those two definitions missing. If we don't want to define a wetland, an adjacent area or a buffer, for some reason unknown to me that it's changed recently.
Doreen,
I don't know
I just did a quick search, and so the version that we reviewed back earlier in the year doesn't have those definitions, and I don't think those terms, because I just searched for hydrology and buffer. I don't think they're
in the text.
I don't think they're even in the text, so they wouldn't be applicable as definitions.
Okay, so look at adjacent area. What does it say?
Let me see. Any area in the village of Mamaroneck immediately adjacent to a wetland or lying within 100 feet measured horizontally of the boundary of a wetland.
Didn't we change that to something else?
No, I don't think so. Not in my recollection, and not.
Because the draft that I saw that was posted on the website and what we
Yeah.
had previously, last time comments were done, as long as we have that, we're done.
Yeah.
Because the last draft looking at, which was on the website, said adjacent areas, see wetlands watercourse buffer.
Yeah, I that's the version that I have that we reviewed a while ago. So it used to be that the adjacent area definition said see wetland watercourse buffer, but that definition then wasn't in here.
Okay,
Yeah.
on
Well,
our
we've dealt with that a
agenda
different
because this was not on our agenda. Or this might be the current law. That's what I'm confused about. Is what's posted to our agenda, what we are looking at? Because it says, see chapter 146 on coastal management. That's the current law. And that's what's on our agenda. So Christie's amendment
Yeah, I agree. What is posted is
It's
the
not
current
on
law.
our
Hmm.
agenda.
Yeah. What is posted, I think you are probably right. And then what I have also Christie's red line open. And that looks consistent with the draft that I had that we read some months ago. So what's on the
Okay, so-
website is not of much use, I don't think, or at least it's a reference point. So let me
Okay,
look at-
so
Let me look at what
where-
adjacent says here.
Yeah, no.
the new law, where's the adjacent area? What reference to it is within the definitions?
Now, it says see wetland water course buffer. And then let me
So
go,
where's the definition, of wetland watercourse buffer?
let me see if we have one.
No, there isn't. I don't know what,
Let's see.
but I checked,
That's-
so I checked the version of the law that was sent to me and it was not on there. So I don't know at what point it got removed.
But Dorian, I agree with you. I was confused.
We have
based
no,
on
we have no
documents.
definition.
I also
So
want
is
to
that what we?
add that there's some definitions floating around somewhere because I saw the other day an actual definition of significant tree, and it describes like historical significance and a particular look and color of the leaves that might be considered significant. And I believe it references perhaps a database or something of trees like this. And I think it might have been in the draft comprehensive plan, which I was looking at yesterday. I don't have a copy on me. I can check when I'm next in the office tomorrow. But in looking at the zoning code, that's not in there. I'm just looking up on, E-code now. And so there's some floating definitions, and perhaps that's related to what you're describing, Doreen, as well.
Well, but that's
Actually
the
not. I
definition of
have the code.
significant tree is on the
1980
definition of
I have the
significant
code
tree
book
is on
from
the tree.
1986 in my house, and that definition used to be in the zoning code. So the code's been played around with a lot. All I'm saying is that our draft that we approved back in April and May, okay, that all of us agreed on, had the definition that I circulated in an email to everybody, which I'll find whenever you sent that email. Was it yesterday, Christy?
Yeah,
Are you saying nobody email?
I'm sorry, what?
Nobody saw this email that I clarified yesterday?
Yes, I saw your email.
No, I saw your email and I agreed that we would talk about it tonight. It does look to me like there should be a wetland watercourse definition. It is not in the draft that was provided to me, so I don't know where that definition is coming from. If someone has that definition, can forward it to me, I can easily add it to the ordinance.
I put it in the email. You didn't get that in the email?
Have it. Hold on.
Yeah, I saw that both of them were in the email.
And
I
it's-
didn't see that they were in the email, so let
And it's
me.
just like one sentence, so it looks
Oh, yes, I have them. Thank you.
pretty straightforward.
Yeah,
There's
that should-
wetlands ecology and there's wetlands watercourse buffer.
I
Those
see
were
it.
the two definitions that were left off of the draft that you worked on.
Okay, those two drops definitions are the only remaining issues we've got.
And on wetland hydrology, Doreen, I don't know if that term is in the document.
That's something that we wanted to add to the document. It was, I'm trying to look up, let me look through sent
But
mail.
if we,
I-
Doreen, do you agree if we add it as a definition, but it's not in there anywhere, that wouldn't matter?
It is among the document, though.
I don't think
That
so.
term is within the document.
Which
Wetland
term?
hydrology.
I don't have it anywhere, so I'm just concerned that what I have might be an old version.
I'm looking through my sent mail, because I can easily forward, if
I
I
did
could
the-
find, if I still have it. It's gonna take a while. I actually have trouble because I'm on a PC. I'll have to get to my, do you need it right now?
Well, it depends on,
Yes.
I mean, yeah.
Okay, let's talk about something else then. Move on to the next thing and I'll look. Otherwise, or we could take a break and I'll find it.
All right, let's table wetlands. Our next issue up is proposed amendment to the village code relating to setbacks and from water bodies. We have been, this comes before us for consistency and not merely recommendation. And we have, you know, if nobody objects, we'll take Parkland first because that's going to have less discussion involved, right? Okay, so we spoke at our work session on Monday about the Parkland or fees in lieu of, and our question to the staff was whether there were other specifically fee provisions that developers paid that were not being cut, because if what we're doing is cutting fees if and only if somebody's providing affordable housing to encourage the affordable housing, are we cutting fees across the board, or are we just cutting the fee in lieu of Parkland? I think the staff has determined that there are not other similar fees that are being left alone. Is that right?
Staff did not see any.
Okay, so there's no other fee that's being left alone. There's no particular reason that the Parkland recreational fee in lieu of Parkland is being singled out here. So I think that answers our principal question. Parkland is in front of us not for consistency, but for recommendation. Does anyone have any other issues they want to discuss with this one? I don't think so. So this one gets a vote. So I'm going to move that we recommend the passage of this local law to the Board of Trustees with no requests for amendment. Do I have a
Wait for a
second?
Second.
All in favor?
Aye.
I'm sorry, I should roll call this. David,
Yes, aye.
Seamus,
No.
Martin,
Aye.
Doreen,
No?
Andrew,
Aye.
and I'm an aye. Tony,
Abstain.
abstain. Okay.
I'm not really paying attention. I'm looking for this darn email.
Okay, but we got your vote. You're against. Okay. The 50-foot setback. The 50-foot setback ordinance. We had a chance to take a look at this on Monday night. And I think we probably have fairly, this is not merely recommendation, this is consistency. And I don't know that we have sufficient information to vote this. We need to let the Board of Trustees know we need more time on this one. Does staff have a report on that? Do they know that we need more time?
Does staff have a report? What do you?
Does the Board of Trustees know that we're asking for more time on this one?
No, they don't. So if you would send them, I guess, if you would like, staff can send them a letter and, request more time on behalf of the board.
Yeah, we're going.
Problem is, tonight, if we don't do anything about it, it's a default approval.
Wait, how is it a default approval? What's the time frame? You're saying the 65?
No, that's for seeker.
65 days is for consistency. So which default approval are you referring to?
Don't we have to come up with consistency within a certain time period of filing the CAF?
It's within making a secret determination. It's 65 days, but the Board of Trustees is the one that makes the secret determination.
When
So-
did they,
So
that's my point.
Um,
When did they make their determination?
Have they made one
Well,
yet?
Doreen, it doesn't even matter because there's that caveat that basically says if you don't have enough information to find consistency, then that 65 days is extended. You don't have enough info. I mean, the Board of Trustees had just referred it to you. So it doesn't.
That was
there-
in September.
Right, but what I'm saying is that wouldn't make any sense for it to be a default consistency because you don't have all the information that you even need to be able to find consistency. So I think it's perfectly fine for you to ask the Board of Trustees for an extension.
Christie, has the Board of Trustees made a secret determination?
Yeah, I believe they made it an enlisted action. They determined it to be enlisted.
Okay, but that's all they've done. They haven't paused it and neglected, right?
They neg-decked it.
When did they do that? You know?
That I don't have in the resolution, so I'd have to go back and look at the date.
Because that would be the earliest it would be completed.
I can give you that answer because I forwarded an email to Thomas today asking about it.
Let me
I
look at the
think
language
with-
of the 65 days, but like I said, that just wouldn't, it was just referred to you. This is really your first meeting since it was referred to you, so that
Actually, I think our second meeting. Because we had a meeting in September and we couldn't do it.
right, but that's still not 65 days, so let me see.
Well, we have to count from September to November, our next meeting.
But when was it? When was it?
Right, but you don't have all the information you need to find it consistent, and that's one of the caveats of that provision. It says, and the submission by the applicant of the latest plans and other materials the commission deems necessary for its review. So that's the caveat. Your 65 days essentially haven't kicked in because you don't have everything that you need to review the application. Or excuse me, review the law.
Understood. I mentioned that at the last meeting. However, we have also in the past found things not consistent, not consistent with our LWRB due to incomplete information. And when we receive the information, we can review it.
I
So,
wasn't not familiar with that, but I know that moving in this case and what we did, I believe there was an application recently that we talked about the 65-day time frame, and it was our determination that it's essentially extended as long as you don't have the information that you need.
it has to be mutually agreeable according to our code. We don't have the other side agreeing yet. Not that they won't. My point is we need to know when seeker was done, when the neg deck was done, and for our next meeting, is that going to be in excess of the time frame that we have to do consistency in?
Okay, we're losing David in 3 minutes, and I don't want to put ourselves in a position where we have even arguably waived this. We do have a history, at least going back a ways, we do have a history of finding things inconsistent when we lack adequate information to make a consistency determination. And while we can get permission from an applicant to extend that, right now we're not in a position to communicate that quickly with the Board of Trustees. So I'm going to say that it's possibly an abundance of caution, but so that there's not an argument that it becomes automatic, I'm going to move for a vote that this is not consistent by reason of incomplete information. Do I have a second?
Second.
David?
Yes.
And I agree with that. Seamus?
Yes.
Doreen?
Yes, but I would add a condition, not a condition, but I would add to it, we are seeking an additional time frame. It's not consistent, and we seek an additional time frame.
That'll be communicated.
You could just restore.
Martin?
So I'm yes.
I'm sorry, Martin
Yes.
and Andrew? You're muted.
Sorry,
Andrew.
Thomas, I lost you there for a minute. Can you just restate it real quick, please?
That we are finding, the vote is to find this this law inconsistent by reason of insufficient information to reach a consistency determination. And we'll
Yes.
communicate.
Yes.
Yeah.
Yes. Yeah.
Okay.
Yeah.
All right. We have a unanimous vote. We lack sufficient information to find this consistent. The board is not consistent. We'll communicate to the board that we're seeking more time to complete our review. Okay, that takes out of play any argument that we've automatically waived it or that we needed their permission to do that. Is there further headway we can make on the 50-foot setback tonight beyond the discussion that we had on Monday? I think we sort of all understand what our concerns are.
I have gone over it, and I also spoke to planning. I had some points to make. If we're not going to discuss it much more today, I have to get off within a few minutes, then we're waiting for a
I know
call.
you do.
But I do have some. I don't see this as a clear setback. I don't quite understand why it's being done the way it is. And I also think that if you take a look at it, it only applies, if the intent is to have a 50-foot buffer area on all construction and all improvements, it doesn't provide that. As I read it, it only applies where there's site plan approval or subdivision. Because if you read that and then you follow it, you can trace it throughout. It says it's required for any building, structure, parking area. It says otherwise requiring subdivision or site plan approval. And the sections amended as you go through it are all dealing with that, which means it really doesn't deal with a generic across the board item. That's one point. The other point, just to throw out at the table, is there was some comment when I said this is a zoning change that it was more of a permit, a special permit. I don't see it as a special permit. And if it is, I think that doesn't really cut to accomplishing the goal here. A special permit is a conditional approved item. You have to just meet certain conditions. This is not. This is basically, it says, okay, you can only, for example, dry cleaners originally were the ones where you could have a dry cleaner, but you needed a special permit because of the safety concerns. I think they have to decide if this is a 50-foot setback, then that's what it is, and they can vary it, they can get a variance. If they don't, then I think you're really allowing it subject to certain compliance issues. And I have a host of other comments, but I think the biggest comment I make is that I think this only applies to site plan or subdivision, so wouldn't apply to residences. And I don't know how this has come up in the past and what have you, but I think that's sort of important to see who should be deciding this down the road and what the commission's role should be. And on that note, I apologize, but I do have to go because I put off a call the other night. Now it's on for tonight. So it's about establishing a cemetery.
We've all been there. Not the cemetery, but the need to go for a call. Okay, thank you.
Haven't even put on that, I could use it, but thank you anyway. Okay, be well, have a good night, and stay safe, everybody.
You too, David. Bye.
Thank you, David.
Thank you all.
Okay. We've dealt with 50-foot setback. We've dealt with parkland. We've dealt with with the tree ordinance. And the LWRP, we are essentially in a holding mode so that staff can fully understand what we've put together now, because there's been a lot of turnover in personnel, which is understandable. This is the biggest thing we'll do, amending our LWRP, and we want everybody to understand what we're doing and why we're doing it. If anyone's got a report on that, or if staff have any questions that we might be able to answer now, that now's a good time to raise it.
None at the moment.
Thank you.
I sent 2 emails around regarding information that I said I would send to everybody. I hope everyone received it. on the LWRP update.
Yep.
And I found where one of the wetlands law drafts that we reviewed is, but I can't send it from my iPad because it's a DocX. So I'm working on it I'm almost there. I mean, I can't believe none of us have a copy of that, you know? That's what happens when we only respond to one person.
Well, the problem is, Doreen, is that you're citing something specific that you've seen, so it relies on
Right.
your finding.
I get it. But I want to do a search for that email and the person's name, but I'm going to lose it again. And it's you are chair, Mr. Burt.
I'm sorry, what, I missed what you just said.
I want to do a search instead of looking for the date on the email. I don't want to miss the email. The only way I can do it is by date, because I don't want to put in a search and then spend all this time doing it again. I said I'd like to put your name in, Mr. Burt.
Yep.
In my address, you know, in my search. But it's not working that way.
William,
I don't want to put this off.
sorry, Doreen, one moment. William, do you have access to any of Greg's files? Because I assume that Greg should have, or Betty Ann should have, all of the versions that have been reviewed and revised.
I'd have to look. I don't know. I'd have to look.
All right, because that
And it
would
would take some time.
be one of the ways that we can find this.
If I look back through my emails, I see that Tom, you sent around a red line June 30th.
Sounds right. Hold on.
26.
So do you want me to forward that to you, Christy?
I thought that
When you asked,
I had received something from Thomas, and that's the version that I used to draft. So let me see if that's what I have, or give me one moment, please.
6 was the last day for comments, I think, or that was in February when you would ask for comments, and that's where it appeared. I don't know how it dropped off the where is this email? This is crazy. It's in my iPad. I
The title
can't.
of the file, Christy, is 2020 LWR. It's redlined 2020 LWRP.
Could you forward it to me?
Yeah, I can.
That would be great.
That definition in there, Martin?
I don't know. I didn't actually open the file. Hold on a second. I'm sending it to Christy.
But Martin, that's the LWRP. Aren't we back on the wetlands law?
Yeah, no, we're not on the LWRP. We're looking at we're looking
Yeah.
for wetlands.
Yeah, that's a different. That's
She
different.
keeps- oh,
Let me look at all the
Doreen
emails
kept saying
sent to you.
LWRP, so that's why I thought that's what she was talking about.
Yeah.
Yeah, no,
Hang on,
we're bouncing back and forth from topic to topic.
give me one more.
Yeah, I don't really have anything. I don't think on this topic between
Here's
April. Yeah, go ahead.
I have an email from the chair on July 15th, and it said this should be the last version.
Does it have the definition?
I'm double checking now. No.
I don't understand why I can't do a search on a PC just for your name, Thomas, and not get all the emails that were sent to you with your name. Do you remember the last date that we had to place comments in?
No.
Because that's
No,
where I pulled off. Hang on. That's where I pulled those definitions from.
I mean, you are correct that they must have existed at some point since another definition refers to them. I just don't, and I have the definitions from you now. My only concern is that what we're using here may not be the latest version. However, if the rest of the board has looked at it and is in general agreement, I don't see why we wouldn't move forward.
Well,
I agree in part with that. I mean, I think I continue to only have one comment, which is the same comment that me and Tony surfaced back in April, which is that there's a little bit of language around something that looks like mitigation. However, it's controlled by the commission. So I think I'm fine with it. But I think that the wetland watercourse buffer obviously needs to be in there because I think it's a busted document without that. The water hydrology, that's not in there. That it's not in there now, whether it should be or not. Yeah.
It's wetlands hydrology. It's wetlands hydrology.
Yeah, but what I'm saying, Doreen, is right or wrong. No judgment there. It's just not in the document at all, the word hydrology. So we don't need the definition unless we can figure out why we need the definition.
Why, did you do a word search on the document to see if wetlands hydrology is within the document?
I did. That's what I did. And
So
Christie, I
it's
think you did too, right? Are you confirming that?
So we don't need we don't need to define the term.
Yeah, so I'll take wetlands hydrology out. Watercourse buffer is in.
And then that's what.
You know what's bothering me? I just had the date of that email and couldn't send it because it was a docx. And now I can't find it again. I'll find it though.
Yeah,
Okay.
it shouldn't affect whether you can send it or not. So in my search, the only one that I found was way back in February in my historic emails.
Do you have that document though?
It could have been named something else. It's the
No,
very.
you don't
first-
have the,
I have the very first one that Chairman Byrd sent around.
I found it, 219. Let me see if I can find it on the
All
PC.
the way back in February. Okay.
Yeah, that's the one. That's the one I'm talking about. Yep.
Why, it's really bothering me. It's not in my sent email on my PC here. It's really driving me crazy. And I can't send a docx out of my iPad. Let me just forward. What if I just forward the email back? Who should I send it to? All?
Send it
I
to
just-
everybody.
Yeah, I just forwarded mine to Thomas and Christie. So see
Thomas,
if
I'm gonna
that's the correct.
I'm gonna
document.
forward it to you and Christie.
Chapter 192.
I don't see the definitions. Hold on.
Wetlands and water courses.
The one that was just sent to me, I don't see wetlands buffer from Martin. Now let me check Doreen's.
It's right above landward boundaries of a wetland or wetland landward boundary. It's underneath the definition of wetlands.
Hold on, I'm looking one moment.
All other areas that are comprised.
Yeah,
of-
this is the first time I'm seeing it, but Doreen, these are also, it looks like these are your edits. So were these adopted by the board or by the commission?
My edits were in Aqua, right?
I see yellow. No, I see yours come across as yellow to me.
I circulated a version that took almost everything from Doreen's. So while these are Doreen's edits, I thought they ended up.
I'd
in-
have to run a red line to tell you whether.
right,
Um,
Can
look,
we
you
all,
could-
run it, but I've done so much, it's gonna come across as a mess because of the fact that I put it in a new format.
All right,
so let's ask a crazy question here. Since we don't have a definition for adjacent area, and I circulated by email what was in the document here for wetland watercourse buffer, the specific area surrounding a wetland watercourse extending 100 feet horizontally away from and paralleling the wetlands watercourse's boundary. Can we adopt adding that to the document and send it to the Board of Trustees? If we amend it that way?
well, the concern
like-
now is that, you know, other stuff may have gotten dropped out. As much as I hate to do it, I think, you know, it's going to take a top to bottom read to make sure that we're dealing with the version we think we're dealing with.
Okay.
If you
I
give
Oh,
hate
me
to say
1
that,
minute, I can try and run it really quickly because I have the clean version that you sent me in July and then I have this one, so I can try and run.
Okay.
that. So give me 1 moment.
Okay, that would be really helpful.
Thank you, Christy.
Sorry to make an issue out of it, but we don't have a definition for adjacent area. That's clear in the draft. And I don't recall adding that at all, seriously. There are a couple of other edits that I made in Aqua, and highlighting it. And that's probably not a nice thing to do when someone's working off a document, but
Can someone look at the version that I circulated, just because I'm on one computer, and look for a definition for pollutant?
Yep, I can do that.
Thank you.
Version 3, right?
It's not defined. It's used in section 1A, 8, and 9, but it's not.
Okay, so Doreen's has pollutant.
But it's not. Well, actually, I don't know if that's how these. it's
Yeah,
not-
there's actually, it looks like there's a few changes that,
the only reason why I sent that is that was the only one I could show you where the wetland watercourse buffer was. That's not necessarily the last one. Actually, I don't know what happened to the last one, but those, at the time, Thomas wanted all of us to individually just email him, so.
Well,
Thomas, do you have the,
we're
last-
stuck with that. We're stuck with that procedure by open meetings law. So I don't like
oh,
it.
I get that. But do you actually have the last final version that we adopted, that we all agreed on?
I thought I did, and I thought that was the one that I sent to Christy for her red line. But now there seems to be some unclarity about that.
Actually, hey, Christy, I just did a comparison versus the first document I sent you from Thomas and your new document.
Mhm.
And the exact same wording appears in both of them. In the new document, you have it as number 8 and number 9, and in the old document, it's H and I.
So I changed the formatting to match the formatting that is in our code already.
Right. But
So
yeah,
which
the
one-
word pollutant only appears twice.
Yeah.
It appears in those two sentences, and it's what you've changed it from H to I. It's 8 and 9 in this one.
So it's not used as a definition.
No.
No. So in the one Doreen sent me, it's a definition that looks like there are some other edits. I mean, my suggestion would then be at this point, either you can move forward with the law as is, the one that you have in front of you, the wetlands version 3 with the addition of watercourse buffer. If the board's not comfortable with that, your other suggestion is that we sort of do some digging here to figure out what the final version is, and then I can add any changes that are supposed to be in wetlands law version 3 from that final version.
Well, I don't want to tell the trustees that they should pass something if we're not sure that it's the version we agreed on. So painful
Shouldn't
it
that
is.
have been on one of our previous agendas? That they were on our agendas.
The one of the ones that I had pulled from the agenda was the one that Thomas sent me. So I'm really not sure what, I looked at a previous agenda from January. It's not in there. I'd have to look later. Let me see if I can pull one up from March.
I'm going to try that while I'm sitting here too.
I know that I had to ask for it because at some point it wasn't on the agenda. So give me a minute. As of February, I don't see it.
I believe it was in May that we finally.
So there is a
William,
version.
is it possible to see the minutes to see where we finally agreed? And maybe it's on that agenda?
I have to go back and look.
But is there a way to search the minutes for, like draft wetlands law rather than going back through everything on Novus?
Again, from my understanding, the minutes are captured in a Word document. So in order to do that, we'd have to go back to all of the minutes and we'd have to type in and conduct a word search. So it's just as it would be just as time consuming to go through Novus, either way.
Oh, I'm not asking you to do it. I'm just asking if it's possible.
So the same version is online all the way through June, and that's the version from March 27th. So let me check what you have for July.
Is it really a big deal?
Well, look, if somehow a version got dropped and this isn't the version we all agreed with, yeah, then that is a big deal. So tell you what I'm going to do. We're going to put this one over. As much as it pains me to do that, because I keep thinking that tonight's the night we're going to vote this. I'm not going to vote on a version or ask you to vote on a version and then find out that the version we all, voted on is not the one we all thought we did. So this is going to be on our November agenda. We're going to vote it. I will be absolutely certain that the version I'm asking you to vote on is the version that I think is final, that has all the changes that we all agreed to. Because when we pass it, we're going to tell the Board of Trustees it ought to become the law, and that's going to be that.
Thomas, do you actually have the last version? Because you were the one that we gave edits to, and I'm sure you put the last version together. So you would be the one that has the last version, correct?
But the Board of Trustees
thanks.
but the Board of Trustees needs a red line in the form that they need it in the document that Christy put together. She has to do her board specific redlining against a version. So, if I come up with what I think is the last version, that doesn't help us now. Christy really needs to redline it, have it board ready. It is what it is.
Oh, I understand, but she's put so much work into it, and I know when I do work like that, I make mistakes. I'm not saying she is, but maybe it would help if we got the latest version so that when she sends the version, if people want to look at it side by side to make sure it works, that's fine. Not that I want to edit your work, Christy, but I'm saying it's easy to make a mistake when you do this work.
Okay, I understand your point. Okay, so that brings us to the end of the administrative items on our agenda.
Can I just make one more point? So I think when you're going through this, Christy, I think one thing to look for is like under hydric soil in your document, it says, soil saturated, blah, 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 but it says, and as further defined under wetland. And if you go to wetland, I think that's exactly what Doreen's talking about. I think that part, that just make sure that if there are things that are saying it is further defined someplace else, make sure that it is.
So I All I did was take it and redline it. I have not reviewed it because I was supposed to do that at the Board of
Oh,
Trustees.
okay, then
So
I guess.
if you, so
for
that's
us
why
to do.
some of these things
Okay.
I didn't, I didn't catch it or I didn't see it because I didn't review it for that. I truly just tried to put it in the form that would be helpful to you to transfer to the Board of Trustees. So
And you did a great job at that. So we'll take that on, right, Tom?
We're gonna have to. Okay, I will do that. That's on me. Okay, I think we've reached the end of our agenda items. Unless somebody has something specific that we can address now, I'll entertain a motion to close the meeting.
Chair, one other item, since everybody is together. Just like to have a quick conversation about your next work session date.
Oh, yeah, thank you.
And planning staff would suggest that the commission standardize it so that it is 8 days before the actual meeting. Which would mean that your next work session would be November 10th. Is that okay with everyone, or how does the board want to handle this?
I can do that. I think we actually made a lot of progress, even though there's a lot of stuff in front of us, especially these administrative items. And I think at least until we get some of this backlog down and get some things handled, it's really helpful to have another work session. So I'm in favor of the work session 8 days before until we put ourselves in a position where we don't need them anymore.
So can I make a further clarification on that? Are we going to do a special meeting, not call it a work session? Because our rules and procedures say that, and the specific agenda be set for that? Are we going to have the same agenda like we did this week? Because I was very confused as to what we were going to review on Monday. I didn't know whether we were going through the full agenda, that was on Monday, and because it was exactly the same. So will an agenda be set for that special meeting? Because that's what our rules and procedures say.
We'll have a special meeting. We'll have an agenda set.
Great,
I guess
thanks.
technically it's a special meeting, but really it's not for the applicants to appear in front of us. It's just for us to review. If there are applicant matters, we'll do it only for completeness. Do we have everything in front of us? Not for substantive deliberation, which we shouldn't do without, the applicants being involved.
Sounds great, Thomas. Thanks.
Okay. All right. And with that, I will entertain a motion to adjourn.
Second.
So moved.
All in favor?
Aye.
Thank you for your time, folks.
Thank you, Thomas.
Good night, everybody.
Good night, everybody.